Once again, very, very happy and glad to be here, of course, on invitation of Miss Malvika, who asked me specifically to speak on topic of the law of evidence. She asked me, you choose any particular topic, may it be a snippet of the evidence, but you speak on evidence. I was frankly desirous to speak upon the law of injunctions because I had some very wonderful experiences on the law of injunctions in my recent practice. So I wanted to share that. I wanted to speak on that. But since Ms. Malvika suggested that you speak on the law of evidence, I said, all right, let us speak on the law of evidence. But suddenly I realized that what I wanted to speak on the law of injunctions would be nothing different on the topic that I have chosen, which is burden of proof and shifting presumptions. Now, you may get puzzled that if I wanted to speak on the law of injunctions, which is a part of civil litigation, civil practice, where is the business with the Indian Evidence Act 1872, which we usually find as a part of the 3-in-1, or what you call as the criminal manual, where we find the IPC, the CRPC, and the Evidence Act. It is certainly relevant. Let us see how. See, the chapter of burden of proof, the legislature has been very wise enough to use the word burden. The term burden has been used. It is not like some responsibility or a mere onus. It is a burden because lawyers and some of you interns who have practiced, who have been into the trial courts, I do not speak for the writ courts, the trial courts will come to realize that it is really a burden for the prosecution to go across the mind of the judge and convince the honorable judge that there is some sense in what we say, and this is something what you want as beyond reasonable doubt. So all that this concept of burden of proof expects from the prosecution is you tell us something that is beyond the shadow of reasonable doubt, nothing less than that. You tell us, then only we will hold the man guilty, accused by you. Before we go into the provisions, I would like to share a small incident, not an incident, but a litigation that I was recently arguing, and what happened qua the incident that I remember it so far as the provisions of the Evidence Act are concerned. Because the study of the Evidence Act is, in my view, the only study where one cannot really understand the effect of the law, the purport of the law, the meaning of the law, merely by reading the black and white in the book. This is something that one must lead by examples. When I was a law student, I did not limit my study only to books. I went to commentaries, I went to digests, I went to volumes of the SCC, etc., judgments, not only in the physical form, but also in the soft copy form on the internet. But more than that, there were some good videos available on YouTube and such platforms where good speakers had spoken something on the law, and that was incidentally recorded and uploaded on YouTube. Unfortunately, so today there is no good lecture. I repeat myself, there is no good lecture on the Evidence Act on the YouTube or any other such medium. And I say it with confidence and with little research. Coming back to my litigation, which I was sharing with you, I appear for a charitable trust. There is one such charitable trust which has approached me to argue its litigation. The charitable trust happens to be the owner of a particular building where a school is run, a college is run. That matter is yet pending, so I need not name the parties. Rather, it is better in the interest of the parties and also myself. So the building is being run since it is owned by the charitable trust. What happens is that the trust appoints a particular gentleman as an authorized representative. That gentleman enters into an agreement with some other trust and gives away the possession of the entire building or part of it to that other trust without consulting the original owner, that is the trust of whom he is a representative. What happens pursuant to that? That when the trust comes to know that this is some foul play, this is some fraud that he has played upon the trust, that is, he has entered into a contract without consulting the original trust, who is the original owner, the trust dismisses him not only as the CEO of the trust, the representative of the trust dismisses him as a member itself by way of following proper procedure. After some years, this second trust, which if you remember, who had been granted possession by way of this very agreement, who is now in possession of that building, it is in fact occupying that building, running it, running some school, running some educational classes in it. That trust says that the representative or the so-called representative is now trying to barge into the premises and trying to forcefully evict the occupants out of the building. So they run to the civil court saying that please grant us an injunction against it. Please grant us some protection against it. In the civil suit, I am also made a party since I am the owner. I vociferously argue on behalf of the trust that, see, I am the owner. This is an agreement which is a bogus agreement on basis of which the plaintiff trust is now claiming some protection. This is completely a bogus agreement and it ought not to assist the plaintiff. I argued the matter for almost an hour or more. I really don't remember. The judge also appeared to be convinced. Everybody appeared to be convinced that yes, this is a bogus agreement because on the basis of ex facie documents, I could show that this is something that is against the interest of the trust and the trust could have never consented to such an agreement. But when the matter is reserved for orders and when the order is disclosed, the learned judge in fact proceeded to grant an injunction in favor of the plaintiff trust. It protected the possession of the plaintiff trust. I, as an advocate of the owner trust, I was really puzzled that what is this? This ought not to have been done because I had made my pleadings very clear, in which I had shown directly on the face of it that this agreement, or rather the fulcrum on the basis of which an injunction is sought, is not the correct fulcrum because it is a bogus document. But then I thought a little upon it. Can the judge, or rather could the judge have gone into the validity or genuineness of the document, that is the agreement, at this stage? Or should he wait for the evidence stage to come where I could assert that this is a bogus document and I could in fact prove that yes, this is a bogus document by way of pleadings and testimony and evidence. And there the role comes of evidence, where at an injunction stage, you can show a prima facie case. You can show a balance of convenience. You can show that there is some irreparable harm that may be caused to me if an injunction is not granted. But where is the question of provement? Where is the question of evidence insofar as an injunction is concerned? And hence the learned judge, although the order was against me, but I must appreciate the position of law appreciated by the learned court, where despite passing an order against me, I appreciate the learned judge that yes, what he thought was that there is some sense in the agreement, at least at this stage. Whether the agreement is true or false is a matter of evidence, which can be seen at a later stage. And now thus we come to the law of evidence, especially the burden of proof chapter, where I must tell you with confidence that one can never understand the purport of this chapter, every single provision, unless and until it is led by evidence. It is rather led by proper examples. So unless you illustrate it by way of proper examples, it is really not possible. Certainly not possible for one to understand the purport of it. Let us go into it one by one. An average human being, I know little bit of psychology. An average human being cannot concentrate for more than 45 minutes. I have been allotted 40 to 45 minutes, in which I have already eaten up 15 to 16 minutes narrating my litigation, narrating my experience. Rest of the time, I will try to cover up these provisions. These are merely 14 to 17 provisions, but they really rule the doors of and evidence the doors of a trial where evidence is appreciated. Before going into these provisions, I would like to tell you something that in criminal law, as law students, probably most of you are belonging to the final year where evidence is being taught. In criminal law, the provement aspect is and has to be beyond reasonable doubt. That is, it has to be so convincing, it has to be so confirmed that it can be termed as beyond reasonable doubt. This and nothing else. That is the test. But in civil proceedings, one need not prove it to be beyond reasonable doubt. It is dependent upon preponderance of probabilities. I will tell you what preponderance of probabilities is. But you see, the law of evidence, which was drafted by the British men, it was drafted by the Englishmen, had something in their minds where they drafted these provisions in such a manner, and it is still followed in their country, it is still followed in our country. Of course, when the prosecution starts a trial, there is no evidence at all because it is yet to open its case. It merely has an accusation by way of a charge sheet. It says that so and so is the charge sheet, and we think that the accused should be declared guilty. So the court says, all right, you prove it by way of evidence. So in the initial point, there is no evidence. Then there can be a stage where one may call it as a scintilla evidence. Note this word, scintilla evidence, where there are tiny traces of evidence, but still there is no guilt, which is beyond reasonable doubt. There is no complete evidence. There is only scintilla evidence. That is step one. I am telling you what was in the minds of the lawmakers, the draft individuals, where they were preparing the draft and they had certain points in their mind that unless and until reasonable doubt is crossed over, we cannot call it a guilty mind. So scintilla evidence. Then the prosecution has to go a step further from scintilla and it will have to raise a reasonable suspicion. Reasonable suspicion is something that you put a doubt in the mind of the court that yes, there is some sense in the prosecution, there is some sense in the charge sheet, and there is reasonable suspicion. But still, that is not sufficient for you to say that the man is guilty, mere reasonable suspicion. So you go a step beyond that, where the prosecution will have to show that there is some probable cause. So this is a step beyond it, where one will show that there is some probable cause beyond reasonable suspicion. And hence we are proceeding against this man, and hence he should be declared guilty. But again, that is not sufficient enough for him to be declared guilty. Beyond that is preponderance of probabilities, where the civil litigation survives and probably it ends as well. Preponderance of probabilities, where one will have to show that there is a better case of the plaintiff or better case of the defendant, better case of the prosecution, better case of the accused persons. So here there is no complete guilt or complete provement. Here the case is only who is better performing. On a better performance, what we call in law as preponderance of probabilities, it can be held that there is sufficient ground for saying that the plaintiff has sufficiently and evidently asserted his right in civil litigation. But then so far as criminal law is concerned, that is not sufficient. You will have to go beyond preponderance of probabilities as well. Then you will have to bring some convincing evidence, some convincing grounds. And after getting convincing grounds, then you can come to a conclusion, as in the court can come to a conclusion that yes, there is sufficient guilt and he should be convicted. You see, the principle in criminal law is the adversarial principle, where beyond reasonable doubt, beyond the shadow of reasonable doubt means what? That if the defense, that is the accused, raises some suspicion in the mind of the court, may it be the minutest suspicion, or it may bring about a version which the court believes can, yes, there can be this kind of a probable version. If I take you to this Talwar case, in fact, there was a film, it is a wonderful film. For all those who haven't watched it, must watch it. There were 2-3 versions of the murder having taken place. There was no doubt, even as for forensic experts, that yes, the murder has taken place. but there were 2 to 3 versions of that murder. And once the parents, who were the accused persons, were successful not in showing that they are innocent, but in showing only so much that there is some doubt, and there is another version which is again a probable version, that led to their acquittal by the Honorable Allahabad High Court. Now, of course, the Supreme Court is seized with the matter, since the Uttar Pradesh government has taken up the matter to the Supreme Court seeking conviction. But when the parents were able to show the court that yes, there is a reasonable version which is probable, and that carries along with the prosecution's version, that is sufficient enough for an acquittal. This being the foundation, let us go one by one with the provisions. I must really thank all of you to be present on the first day of a longer vacation. I must call it a longer vacation. You have 2 holidays and then the real weekend. Probably myself as a law student would have never shown the efforts of attending the lecture, even if I would have been in need of it. I was a student who used to open the textbooks, the law books, only one day prior to the exam days. But still, so far as the evidence law is concerned, I must tell all of you that I had actually by-hearted each and every provision, not deliberately, but I had studied it so much in depth that I had incidentally by-hearted provision A to provision Z by heart. I knew the language of it, I knew the purport of it with illustrations. Of course, my practice may not be that much into criminal law, since my practice is much into the higher courts, that is the writ courts, where one need not again and again open the Evidence Act. And hence the by-hearting memory has gone away, or has washed away, I must say. But still, I will give you some examples where a better appreciation of the evidence law will take place. Let us go to the first provision. This is part 3 of the Evidence Act, burden of proof. See the first provision, that is 101, burden of proof. What 101 says is that if you wish to assert a right, then you must satisfy it by way of a particular fact. Take an example. I say that my father has made a will in which there is a property and that belongs to me, because my father wished in the will that it should belong to me. So there are 2 things that I must prove. One is that my father is no more. That is by way of a death certificate. And second is that the will is a genuine will, because I will have to prove these 2 things in order to come to a necessary fact which the court requires, that yes, there is some sense, and that will lead to an evident fact. So the first provision says that if you desire a judgment of the court in order to ascertain a right or a liability based upon a fact, then you must prove the fact. In simple language, one who comes to the court with a fact must prove it. That is the simple logic behind it. Next provision is, on whom does the burden of proof lie? I've already answered it. The burden of proof lies upon the person who asserts the fact. Take an example where a person says that I own a particular land, but that land is now possessed by another individual. If you remember the story of that trust for which I had appeared, the trust says that we never gave over the possession of the land to anybody else, but still now the land belongs to somebody else, or rather the building is occupied by somebody else without our permission, which couldn't have been possible. So the trust will have to show 2-3 things. One is that the possession of the land was never given by us, and the land and the building also belongs to us. Here there is a simple illustration. A sues B for land of which B is in possession, and which A asserts was left to A by the will of C. So C happens to be B's father, and A says that, see, these are examples which might appear to be somewhat confusing at first blush, but if you read it with concentration and if you read it with simplicity, that will make things simpler. I will try to make them simpler. A says that I own the land because somebody's father, who is now in possession, had by way of a will given that land to me. That is A's case. So he must prove two things: that there is validity of the will, and second is that the possession is illegal. Now that requires some trial, that requires somewhat of an evidence, which is not possible unless you cross over the injunction stage. So burden of proof lies upon the person who asserts a particular thing. Now let us go further. If there are facts which are admitted, then on whom does the burden of proof lie? The law says that the burden of proof will lie upon the person who would fail if no evidence was given. Take an example again of this possession, where, or forget possession, let us go into a contract where A enters into a contract with B. A will here have to prove that there is a contract and it was a valid contract. Suppose if A fails to give any evidence and B also fails to give any evidence, where the contract says that there is some recovery of money due from B. So as per the contract, by way of a license fee or rent or anything else, B was liable to give some money to A. A doesn't give any evidence, B also doesn't give any evidence. Who would fail in this? Would A be able to recover money from B unless he gives some evidence? The answer is no. And hence it is A on whom the burden of proof will lie so far as recovery of money is concerned. Go a step further, where B says that yes, there was actually a contract, but it was obtained by fraud. Maybe the contract says that I was liable to give some amount, but this contract was obtained by way of fraud. These are not my signatures. What will happen in that case? Here, the burden of proof will get shifted from A to B, because B says that this is something by fraud, although I admit the existence of the contract, but this is something by fraud. So see how the shifting takes place from A to B. Let us go to the next provision. Burden of proving fact to be proved to make evidence admissible. This is nothing but where A says that he wishes to prove a dying declaration of B. A says that there is a dying declaration of B where B has admitted the existence of some facts and he has given me some estate. So here the burden of proof of A will be only to say this, that B is dead. If he wants to prove a dying declaration, which is one fact, he must first prove the dying declaration that B is dead, so as to prove B's dying declaration. So you see the interrelation or the interdependence, where one fact is dependent upon the other. So in order to prove fact number B, you will have to first show that how fact number A was existential. In criminal law, there are various exceptions where one will find that one will take exceptions of insanity, one will take exceptions of self-defense, one will take exceptions of grave and sudden provocation. So where the individual accused says that I was in fact provoked, I was insane, or I was acting, or I was in fact provoked, or some exception which would save him from being guilty, from being declared guilty. Some exception, there are so many exceptions. Even grave and sudden provocation, if you see section 325, which makes an act punishable for having caused grave hurt to somebody. But if that provision is accepted, EXCEPED, accepted by way of section 335, then you are saved, because that was an act under grave and sudden provocation. So you will not be liable for causing grievous hurt. So once you say that I was insane, I was provoked, that was grave and sudden provocation, so on and so forth, it will be upon you to prove that you come within an exception. So the burden of proof is upon the person who claims benefit of the exception. There are certain facts which are completely within the personal knowledge of a particular person. Say, for example, there is a dowry death in the house, where a woman, in fact, she has burnt herself alive. She has committed suicide, alleging cruelty against her in-laws for dowry demands, illegal demands, etc. What happens in that case? The cruelty aspect is specially within the knowledge of the in-laws which were present during the time when the death has taken place. So once it is within your own knowledge, the prosecution must prove at least prima facie that it was within the special knowledge of this man that this death has taken place due to so and so reason. And hence the burden of proof is not upon us, it is upon the accused persons. Pausing here for a moment, you see this, the Supreme Court has gone ahead and said that this provision 106, which I was discussing with you all, is in fact an exception to the first provision. Go back to 101, where it says that one who asserts must prove it. If you want a right or a liability by way of a court order, you must prove the existence of the right or liability by way of a particular fact. But now come to 106, which says that if it is within your special knowledge, then you must prove it. While interpreting criminal law, the Supreme Court has said that 106 is an exception to 101. How an exception? The prosecution must first prove, as per 101, that it is within the special knowledge of the accused. So you prove that it was within the special knowledge of the accused, and it is then 106 comes into existence, where as per 106, the accused person who is now facing a provement of having some fact within his special knowledge will have to now prove that no, this is something wrong, it was never within my special knowledge. So he will have to discard or dispel that presumption which is drawn against him, so far as the burden is concerned. So he will have to discharge the burden from himself. That is 106. You may have read about testamentary petitions in the Honorable High Court, and in some places, even in the city courts, district courts, what we call them. What happens is that when a man is missing for a particular period, I'll come to that period, when a man is not heard of, which people knowing him could have heard about him, then the man is either believed to be dead, or the man is believed to be missing, or the man is believed to be not required for particular purposes. So suppose there are two brothers, one of whom has gone away from his house and he has not been heard of for a period of 7 years. What happens? The law says that now there is a presumption against this man that he is no more, or he is not required to assert his right, or rather his rights over a particular property have now been waived off, because persons who should have actually heard about him, who knew him and who should have heard about him, have not heard about him. So now there is no use in waiting for him. See 107 and 108. 107 says that if a person asserts that one particular person is alive because he has been alive for 30 years and people have heard about him for 30 years, then it is upon him, the burden is upon him who asserts that he is alive, to prove that people have been hearing about him for a period of 30 long years. The very next provision, that is 108, it says, in fact, in my opinion, it shouldn't have been drafted as a new provision, because it is really an exception to provision. It is really an exception to the first provision, the earlier provision, because it starts with the word provided. So it is a proviso, if not an exception to the earlier provision. What it says is that if a person says that a particular person is dead, then he must prove it by way of showing that he has not been heard for 7 years. So go back to the earlier provision, which says that a person is alive. You must prove it by showing that he has been alive for 30 years and people have been hearing about him for 30 years. But if you want to show that a person is dead, 7 years are enough. And you show it to the court by way of evidence that he has not been heard of for the past 7 years, and hence he deserves to be declared as dead. Now, mind you, these provisions are not to be used for securing death certificates or things of that sort. So suppose a family member has not been heard of for about 7 years by reason of him being missing. It is not a presumption that he is dead and you can go freely to the municipal corporation and get a death certificate in his name. That's not the case. The case is that suppose if there is any litigation going on with respect to rights of the parties, what we in Marathi call as Samayik rights, unified rights, then so far as right of the missing person is concerned, it will not be counted because as per section 108, he has not been heard of for the past 7 years. All that section 108 says, do not be under the misimpression, I must call it, that once a person is not heard of for a period of 7 years, he is no more. That's not the case. It is only when the case of his rights and assertions will come in place, it will be believed that now, all right, his rights won't be counted because as per 108, he has not been heard of for a period of 7 years. Keep this in mind. Let us now go to the next provision. There are so many cases where persons say that I am a tenant and he is the landlord. Persons say that I am the licensor, he is the licensee. Where there is such relationship which is existing, or at least having been asserted that such a relationship exists, the law presumes that yes, a relationship of such kind exists. Now, given this presumption, if one wants to say and one wants to tell the court that no, this is not a tenant-landlord relationship. Take, for example, in a rent suit, where the landlord says that he is my tenant and he has not been paying my rent for the past 2 years, and hence please evict him as per the Rent Act. The tenant will come and say, no, sorry, he is not my tenant. He is not my landlord. How does he have the right to claim some rent from me? I have been paying the rent to his sister, who is the tenant, who is in fact the landlord. In this case, the landlord need not prove that there is a tenant-landlord relationship because there is a presumption in favor of such relationships. It is in fact the tenant who now denies the relationship who must prove that yes, this is not a relationship because I want to get accepted from section 109 of the Evidence Act. So 109 says precisely that tenant-landlord relationships, licensor-licensee relationships, principal and agent relationships are some relationships that are presumed by way of law. And one who negates the existence of such relationships has to prove it. So the burden of proof will lie upon the person who negates the existence of such relationship. Precise enough. Burden as to proof of ownership. This is an interesting proposition on which I have had opportunities of handling many litigations. Recently, I was appearing for an auction purchaser who had purchased the flat at a particular place in Bombay by way of an auction. He was given allotment of that flat. He went for his vacations for 5 or 6 days out of his house. He locked the door of the very flat which he had purchased in an auction. The original owner, the loanee who had defaulted in payment of loan and against whom auction proceedings were initiated, loan proceedings and thereafter auction proceedings, and thereafter he lost the possession ownership of his flat. He barged into the premises behind the back of this auction purchaser and he gained occupation possession of this premises, hostile possession. What happens with this now? The law gives presumption of ownership on a person who occupies those premises. Now, as per 110, the plaintiff, howsoever good his case may be, he will have to prove that the auction was correct. I was in fact staying in this house by way of evidence, which will probably require many months, many years, because from an injunction stage to the trial stage, the civil courts is naturally, and especially in Bombay, the civil court is naturally required to take and consume a lot of time because there are so many years, if not a few months, which are spent on arguments upon the injunction aspect. And now the case will have to go for a trial only in which and only at which stage the plaintiff will be able to prove and dispel or discard this presumption in favor of the occupant of the house, howsoever hostile he may be. These are poor stories, these are sad stories, but yes, that is the presumption of law, and it harms the common man, not only common man, every individual who is affected by way of these litigations, who is somehow connected by way of these litigations. But this is the presumption which you will have to dispel away. You will have to discard by way of provement, and that is by way of following the principles of the Evidence Act, principles of civil law or criminal law, as the case may be, and particularly Chapter 3, the provisions of Chapter 3. Even that matter is yet pending, so I refrain from commenting upon the merits of it. Then there is Section 111, proof of good faith in transaction where one party is in relation of active confidence. So the party who claims to be in position of active confidence will have to prove. All the law says that the burden of proof will be upon the party who claims to be in active confidence, say a father-son relationship. The father is in a position of active confidence. Suppose a dispute arises. It is the father who is in active confidence who will have to bear the burden of proof. And he will have to prove certain things which the son may assert or the son may not assert. Then there is 112, which is an interesting provision. All it says is that if a child is born during the existence of a valid marriage, or if it is born within 280 days after the dissolution of the marriage, provided that the mother remains unmarried, then the child will be presumed to be a legitimate child. It will hold the boon of legitimacy. Now, this is a beneficial provision, but that again comes with a twist. What it says is that if the husband is able to prove that when the child could have been begotten, there couldn't have been any coexistence of the husband and the wife, then there is no question at all of legitimacy of the child. So again, the presumption is that the child born during the subsistence of a marriage is a legitimate child. But if the husband later on proves that there was no coexistence of the husband and the wife, of the man and the woman, when the child could have been begotten, when the child could have been conceived in simple terms, then the legitimacy presumption is lost. Section 113, proof of cession of territory. What do you mean by cession? Cession is nothing but ceding. So if this is a law, this is a particular provision which was enacted so as to suit the British times, where the Britishers sometimes ceded their territories with provinces or certain states, where after there was a notification in place that yes, the territory has now ceded with a particular princely state, with a particular regular state, or with a particular native or a prince or a ruler as they used to be, then the notification is a sufficient proof that yes, there is cession, or yes, this British territory has now ceded. So all it wishes to say that now the burden of proof will be upon the person who denies the notification, because the notification casts a presumption on the cession, and the burden of proof will be upon the person who negates the cession, as they call it. Now is an interesting provision, and thereafter we come to the fag end of this particular chapter and probably the discussion as well. 113 capital A, presumption as to abetment of suicide by a married woman. If a woman commits suicide within 7 years of her marriage and there is sufficient proof to show that she was subjected to cruelty before her marriage, before her death, then Section 113 capital A says that the husband and the relatives can be arraigned with the particular offense so far as cruelty and abetment of suicide is concerned. Here the twist is this, bear in mind, here the husband will face the presumption only when the prosecution is sufficiently able to tell it to the court that she was subjected to cruelty. So it is first the prosecution's business, the prosecution's job to show that yes, she was subjected to cruelty. It is then the presumption will go against the accused, who will now have to come and defend that no, there was no abetment, no, there was no cruelty. So a mere reading of the provision at first blush may give you this impression that once a woman commits suicide within 7 years of her marriage, there's a presumption against the relatives and the husband. That's not the case. The presumption is this, that once the prosecution is able to sufficiently prove that the woman was subjected to cruelty, it is only then the presumption will be drawn against the husband and her and his relatives. So first the prosecution and then the defense. These are principles that one may not understand on a bare reading of the law. One may have to see examples. One may have to enter into active litigation and especially active trial litigation so as to understand how the law will actually work in favor of the prosecution as also the defense. 113B, capital B, is again a similar provision where there is presumption as to dowry death. When there is a death of a woman due to dowry demands, and the prosecution first is able to show that soon before her death she was subjected to cruelty, it is then that a presumption will be drawn against the accused persons, that is the husband and the relatives, that yes, this lady was actually subjected to cruelty and harassment. And now you please tell us by way of provement, by way of evidence, as to how and why we should believe that the presumption against you should go away. Pausing here for a moment, these trends, I must call it, where now from an adversarial litigation system, we are now going to a system where we shift the burden of the prosecution upon the accused persons, be it special legislations, be it the Atrocities Act, be it the NDPS Act, be it the schedule, that is the Atrocities Act, be it the POXO Act, where suppose you have some atrocious elements against you, where a person belonging to a particular community as per the SC and ST Act says that there are so and so categories of acts which are committed against me, may not be seriously caste oriented acts, but there is a presumption against the accused that the act has been committed with an intention to harm the person because he belongs to a particular caste. It is you as an accused who will have to dispel the presumption that I never intended to do this act, assuming that this act was committed by me. I never intended to do this act knowing that this person belongs to so and so category, and knowing that it will harm by way of this act that particular person, more so by way of his category that he belongs to. Similarly, with respect to the POXO Act, where it says that if an act of assault, harassment, etc. is done upon the minor girl as defined under the act, it will be presumed that you had the sexual intention behind the act. So it is presumed that you had the sexual intention. The job of the prosecution, you see, has become much easier, where the prosecution will have to just show that yes, there is prima facie basis to show that there is some sexual intention. And thereafter, the presumption is against the accused to prove that I had no sexual intention, so far as POXO is concerned. I had no intention of harming the reputation of a person or making caste-based remarks against the person, if it is the Atrocities Act, so on and so forth. So now we are somewhat compromising, if that is the right word, compromising with the adversarial system of litigation, where there were days where the prosecution had the whole and sole responsibility of proving the guilt against the accused persons. But now it is the prosecution which will just have to show that yes, there was cruelty so far as 113A, 113 capital B is concerned. Yes, there was an intent to harm the reputation of the person so far as his caste is concerned, to assault his caste, to assault him because he belongs to that particular caste, to assault the victim girl because he had the sexual intention. So it is the prosecution's job today to just show that yes, there is prima facie basis to proceed, and then it is the accused individual's job to dispel the presumption. So hence I say that somewhat we are compromising with the adversarial position, which in my opinion may not be totally wrong, but we need to think over this proposition whether the lawmakers had envisaged such a system where the accused person will have to dispel or discard the presumptions against them. And then the last is section 114, where it says that the court may presume existence of certain facts. Here it is a general provision where there are certain human elements, where there are certain conducts, there are some natural events, there is some public and private business. The court will have to presume, given the nature of human business, given the nature of natural business, given the public life, given the private life, the court will have to presume the existence of certain facts. Take one illustration which I can see over here in the book. The court may presume that a man who is in possession of stolen goods soon after the theft is either the thief or has received the goods knowing them to be stolen unless he can account for his possession. What does this mean? That if a person is found in possession of a stolen book, suppose this book behind me belongs to somebody else amongst you. If you see the book on the screen, you say, oh, this man speaking on the screen about evidence is in fact having his evidence book, which in fact belongs to me. So it may be a sufficient ground to proceed against me for the offense of theft because you have found me in possession of the stolen book, assuming that the indications and markings, etc., are very much there on the book. It's not just a book of the same publication. It is in fact your own book. It is me who will have to tell the court, because the presumption is now against me, that I was in possession of the book, not because it was out of theft or it was a product of theft or stolen material. This is my book and I am in lawful possession of the book. So section 114 is a general presumption where, given the human nature, given the natural conduct, given the public life, private life, the court has been given some discretionary power to assume certain things, or legally speaking, to presume certain things, and leave it then to the accused person to prove and account for it by way of evidence. So that is the burden that is cast upon the accused persons. We have now really come to the end of the chapter so far as burden of proof is concerned. I was really happy that I went once again into the evidence textbook, that is the Bare Act, and got to know once again, got to revise once again the provisions of law, which long back I had studied in my law days, especially for my Evidence Act exam.
What is the difference between burden of proof and onus of proof?
There is actually no difference. Jurisprudentially, there may be, but in my opinion, there is actually no difference so far as practical aspects are concerned. Because what do you mean by onus? Onus is the same thing as that of burden. Jurisprudentially, there may be. If you go to see on paper, probably jurists may be able to distinguish that yes, there are these cognate variations, there are grammatical variations, the English of this is different, grammar of that is different. But let us not engage ourselves only into that. My point here is that practically onus and burden is one and the same. Nowhere in chapter 3, where burden of proof has been discussed by the Evidence Act makers, the point of onus is discussed, or even the word onus is used.
Sir, you said in tenant and ownership, tenant and owner case, if the tenant is missing for say a couple of years, and if the municipal authorities have also demolished the construction because it is dangerous for living, in that case, what are the remedies available for the landowner if he wishes to develop his property and the tenant is missing and there are no whereabouts to be found of him? Then what is the remedy for the landowner?
See, the tenant may be missing, but given the facts of your case, are there any legal heirs of the tenant, or after he has gone missing, the room is just vacant? What's the case? Take a case A, that the room is vacant, and assuming that there are no legal heirs whatsoever of this man, then he is presumed to be non-existent. and his rights are presumed to be non-existent, you can seek a declaration in that regard from the civil court, and you can proceed with demolition of the building. But you will have to first seek a declaration in that regard from the civil court. Second is, if there are any legal heirs who are present, then the tenancy automatically gets transferred or subsumed with the other members who are now existing and are acting, or rather claiming to be his heirs. So if any of their rights are getting affected, you will have to carry out the redevelopment subject to their rights.
As far as section 113A and B is concerned, what if the suicide is committed by a woman due to the pressure of dowry? Which section would apply, and how these two sections essentially differ?
113 capital A speaks about the time limit of 7 years. So within 7 years of the marriage, if the woman dies and the prosecution is able to show that yes, there was some mental cruelty which she was subjected to, then there is a presumption which will be drawn against the husband and his relatives that yes, there is mental cruelty, and because of that mental cruelty, this woman has committed suicide. Now you please tell us, why should we dispel this provision? Otherwise we are holding you guilty. This is what 113 capital A says. The essential difference between 113 capital A and 113 capital B is this, that within 7 years, if she dies by way of suicide, then 113 capital A will apply. But if it is after 7 years, then 113 capital B says that the prosecution will have to prove only this much, that soon before her death, she was subjected to cruelty. Soon before her death, she was subjected to cruelty. Essential difference is this, that within 7 years, 113 capital A, after 7 years, but soon before her death, she was subjected to cruelty, 113 capital B. Now, there cannot be any straitjacket formula, at least so far as 113 capital B is concerned, because soon before her death can be anything. It can be 1 day before her death, 2 days before, 20 days before, 1 year before, anything. It depends upon the facts and circumstances of that particular case. There really cannot be any straitjacket formula. But the requirement is this, that there must be a strong linkage between the so-called act of cruelty and the suicide. There must be a strong linkage. That is the essential difference.
Burden of proof in departmental inquiry, evidence in departmental inquiry to CAG reports need to be proved in court.
Yes, because you assert that there is some malfeasance or misfeasance with respect to the report. So you will have to go and tell the court that there is something wrong, for which burden of proof will lie upon you yourself. If there are any other aspects, the speaker may guide me so.
Currently, there is a news of a current Karnataka minister who has been involved in a particular bribery case, and the contractor has committed suicide in a hotel room. And he has sent a WhatsApp message that the minister is responsible for his act of suicide. And since he was in a hotel room with some colleagues, they were not aware of his intention to suicide, and they are not responsible. Now, if in case somebody has to prove that it was only because of this corruption act, this thing, demand of bribe, he has committed suicide. Nobody knows, like, actually he is responsible or the minister is actually responsible. So where does this principle burden of proof lies, on whom?
See, there is a principle, there is a fundamental principle of the evidence law, that when a man goes to meet his maker, he will never lie. So if a person is dying when he is on his deathbed, if he gives a declaration that so and so has happened, or he gives any assertion, if he negates something, then that is known as a dying declaration, that this is the reason of my death, particularly with the precise facts of your case, or the case that you tell me. If the contractor dies, and while dying soon before his death, he says that so and so is responsible for my death, it will be used as a presumption against that particular minister, and it will then be his responsibility to dispel the burden which has been cast upon him by way of the dying declaration made by the deceased contractor.
So will that allegation be sustained or it can be negated by the minister and there is a way out for him?
There is certainly a way out for him if he shows by way of evidence, but the proof, the presumption will have to be dispelled by him. So it is not the case that the prosecution will have to prove everything against him, also including the corruption activities. So far as dying declaration is concerned, the prosecution will have to just prove to the court that, see, there is a dying declaration, and look, this man while dying has immediately before his death made this declaration. Once that is done, step one is done, then the presumption will travel and it will shift upon the accused person that, yes, now tell us, why shouldn't we hold you guilty? Because these are the presumption against you. Of course, if he has a good case, we don't know what his learned advocates are going to present before the court. But if he has a good case by way of evidence, and if good enough to dispel the presumption that is drawn against him by way of the dying declaration, then that can go ahead. He might as well be acquitted if he has a good case on evidence. We don't know what are the evidences involved at this stage.
The question is, in case land belonging to a person A and person B overnight constructs a small room kind of a thing on that land, in whose favor that this presumption of ownership will be there in that case?
So this is an unauthorized construction. Unauthorized, I mean, this has not been proceeded with by way of obtaining the permission of the corporation or the planning body, right?
It may be on a land which does not need any permission, but the title is on A's
What land
name.
is this? Is this land on the moon or something?
There are some colonies where the permission of the corporation or such things are not required. It is only land like in sectors in the urban areas where the exact permission or some particular permission is required. But in colonies, such kind of permission is not required.
I know the Maharashtra Land Revenue Code, which tells me that all water bodies, all lands, everything, all properties, all forests, all trees, all reservoirs, all ponds, etc., which do not belong to anybody, belong to the state government. So the land, if it belongs to the state government, you will have to obtain the permission of the state government, at least, if there is no corporation, if there is no planning body.
It was land belongs to a particular person, not to belong to a state.
And you have built a house upon that land. So the presumption of ownership will be with you, who is occupying the land. The burden of proof will be upon the person who tries to dispossess you. He will have to tell the court that how this is hostile and illegal possession, and hence this man should be thrown away along with his house, because he is in unauthorized construction. He is in hostile possession of my land, which never belonged to him. So the presumption is in your favor. The burden is upon the person, or rather the real owner, who says that this man should be thrown away. Thank you. Bye bye.